Welcome to our March 2023 Your Overseas Home virtual event. Thanks for joining us this afternoon and for tuning into our webinar on the legalities or the legal aspects of the buying process in France. My name is Richard Way. I'm an international property journalist and a writer on the Property Guides team, and I'm going to be hosting this session. And we're fortunate enough to be joined by Leah Maynard from the French law specialist Buckle Solicitors, who is French and a solicitor, French solicitor. And so she's going to be talking through by the French buying process, the legal aspects, French property law, all those things you need to think about in terms of the law when you're buying in France. So it's great to have you today. You might be watching live, but just to remind you, the session is being recorded, so you'll be able to watch it again via the Your Overseas Home website. The recording should be up from Monday onwards, so you can go back, watch, or forward it on to friends and family. Share the knowledge and the experience that Leah's going to give us today. So just quickly, this event is designed to offer you guidance and connect you with the right people who we consider trusted partners, specialists, if you like, who work in the French property industry. And it's a great opportunity to connect with people like Leah, as well as French agents, Beauvillage Immobilier, Chase Buchanan, all the other people who you need when you're buying a property in France safely. So take advantage of having them all in this virtual space at one time. Just in terms of the structure, Leah is going to do a presentation for us. It's going to last about 15 minutes. And then we want to hear from you. We want questions from you guys. Anything that's niggling or anything that triggers a question during the presentation, use the Q&A tool on the dashboard to type your question in there, and then I'll feed it to Leah. If we don't get through all the questions now, or if you would rather approach Leah independently, she's going to be available for the rest of the day in the Buckle Solicitors booth within the main exhibition hall. So you can go and find her there as well. So that's enough from me. Hi, Leah. You're there?
Hi, Richard.
How are you doing? So just tell us a bit about your background first. So how long have you been with Buckles, and what's your experience working in French property law?
Yes, of course. So hi, everyone. My name is Leah. I'm one of the lawyers with the French team at Buckles. As you will have guessed from the accent, I am actually French, but I have been living in England for almost 8 years now. I'm based in beautiful Lincolnshire. I did my law undergrad and grad and Masters of Law in France before I moved to the UK, where I did another master's and then started working at Buckles, where we advise our British clients who have property interest in France in terms of purchase, sale, inheritance, will, so anything to do with the kind of advice you will need when you own assets in France. Within Buckles, which is a big law firm, we are a small team of 3 lawyers, so you should always expect to get very personal contact with us. You will always deal with your lawyer, who will be the person replying to you, and have direct access to them at all times. So yeah, that's about it about me and Buckles.
Right. Over to you for the presentation.
Yes, so how to buy a French property, the legal process. At first, when you start reading about the process of purchasing a property in France, it might sound very involved and maybe a little bit scary, because it is very, very different from the way we, buy properties in the UK. What a lot of our clients very quickly realize is that the French process is actually a lot more secure from the buyer's perspective, and you are a lot more protected than in the UK. The process can seem a little bit longer in that it is almost impossible in France to have a completion happen within a couple of weeks of signing the preliminary contract, but the entire system is really designed to make sure that the buyer has all of the information that they need on the property, and that there are absolutely no issues that can come out of the woodwork after completion. The first step of the legal process is obviously when you make your offer. There is often a lot of confusion in terms of the offer in France, because some people can tell you that you are committed from the time you make your offer, but actually legally that is not always correct. The most important thing to understand about your purchase offer is that it will set the tone for your entire transaction, which means that if you have any key information that you want negotiating or agreeing with the sellers at that stage, ideally you will want them in your offer. Those would be things such as anything to do with the timescales to completion. Maybe you need a little bit more time than the standard process, so you should agree then. Maybe you've got a specific date in time, so you would want to mention this to make sure that your sellers can make that happen to you for you. You would want as well to put any, well, everything will be put through in a formal contract afterwards. If you've got any specific things that you want to agree with your seller straight away, you should also mention them and have them written down in your offer. So that would be, for example, if you want your seller to agree that they will clear part of the property, or that they will fix something that isn't quite right with the property, all of this you should put in your offer. And ideally, at the same time, you should discuss through your estate agent the issue of the deposit, and mainly at one point you expected to pay your deposit. How much will it be? It happens in France. It depends on the area. So some areas you will pay 10%, some other 5%. So obviously that's something that needs to be discussed at that stage to make sure that everybody is on the same page. Very often your offer will include deadlines. Those are very helpful to have, again, to set the tone. So you would have, this offer is subject to a preliminary contract being signed by that date, and then obviously, as I mentioned previously, completion happening by that date. Those are quite important to discuss with a lawyer. So that's at the time of making the offer, that's when you would want to loop us in, because we will be able to tell you, you will not be able to sign a contract in a week's time, so that deadline is already wrong and needs to be changed, etc. And we can tell you, whether something you would want is something that is something realistic, or something that will be shocking to the sellers and makes the transaction a little bit more tense, which are all things that hopefully we want to avoid. Obviously, you need to understand what those deadlines are, because the seller will be committed up until the offer actually runs out. So what you don't want to do is realize that you've missed a deadline and actually your seller has put the property back on the market and you never realized. So that's the importance of the offer document. Afterwards, the most important step in the entire transaction is the signature of the preliminary sale and purchase contract. You would probably see that often it is called a compromis de vente. Sometimes it can also take the form of what is called a promesse de vente. Those are two different types of contract. I will not go into in depth into the difference between them. It is quite technical. They both have advantages and inconvenience in terms of their specific legal feature. But yeah, the key thing is that there will be a contract. When you receive the contract, it will be very, very long. It can be drafted either by the estate agent or by the notaire, but in general, you should expect a minimum of 10 pages. And on average, especially if it's a notaire contract, you will have between 20 and 30 pages worth of French legalese to go through. The contract is very important because it will include all of the conditions of your purchase. The conditions are either conditions that are set out by French law or conditions that are specially negotiating between you and your seller. Standard conditions set out by French law would be, for example, you are purchasing subject to there being good title to the property, subject to there not being any public easements that would adversely affect your enjoyment of the property, etc. And specific conditions precedent that would be negotiated between you and the sellers would mainly be things like your financing. For example, if you need a mortgage, your purchase will be subject to you obtaining the specific mortgage that you are applying for, or it could be something very specific, for example, subjected to the fact that your seller completes this item of building works that they haven't finished, etc. Some other types of conditions precedents that we see is often to do with building work. So for example, you buy a property, it does not have a pool, you are told it can have a pool, but you are thinking that, you know what, if this property doesn't have a pool, actually, I don't want it. So what you can do then is make your purchase conditional to the fact that you do obtain planning permission to build a pool in your property, which means that it will protect you in that if you will not end up after completion with a property only to be told by the local authority, oh no, nobody can build a pool here because X and Y planning restriction. So this is why the preliminary contract is so important, because once it is signed, the process is all very automated and you will not able to go back or renegotiate anything with your sellers. So everything really needs to be laid down at the table at the stage of drafting the contract. At the time where you receive your draft contract, you will also receive a set of mandatory annexes. The main one you will have in all type of property purchase are your French survey reports. I know that in England, we are often used to getting structural surveys done on a property. In France, this is not something that actually exists in the process. Whether it is a good thing or a bad thing, I will leave you to be the judge. However, what you will get are some reports to inform you in terms of whether there is any asbestos at the property, whether there are any issues to do with potential lead poisoning, whether there are termites present at the property or not. And also you will get your energy performance certificate, which has become extremely important since last year due to the fact that France is cracking down on energy inefficient properties and is, battling to get everything fixed and made energy efficient, which means that the EPC has become a key document because you could potentially be committed to carrying out very expensive building work to make the property more efficient. So that's a document that you really have to go through very, very carefully now. Otherwise, the survey reports are for your information only. The sellers does not have any obligation to make good on the issues that could be pointed out by the surveys. But what is good in France is that because you have them before you sign your preliminary contract, it means that you will be able at this time to negotiate anything that you want fixed or not based on the surveys. Another key service that you will have is if the property has a septic tank, for example, then it is important because you as buyers will have an obligation to make sure that the septic tank is compliant with French law within a year of the purchase, and potentially this can be cost up 10,000, 20,000 euros. So again, another survey very important to look at. If you are purchasing an apartment, which is happening a lot at the moment, we're seeing a lot of purchases of skiing apartments, which are very exciting to own, obviously. If you purchase an apartment, it will be located in a building under the French co-ownership regime, copropriété. If that's the case, you will also be provided with a set of what is called Loi Allure, documents. Those documents will give you very important information on the financial state of the co-ownership, how it is managed, what ongoing costs you might be expected to pay, whether there are any major building works that you will have to participate in, etc. So this is, again, very important to make through those documents with a fine-tooth comb, just to make sure that you understand what kind of financial commitment you are making when purchasing this apartment. The preliminary contract can be either drafted by the notaire or by the estate agent. Very often what will happen is that you will be in France when you are making your offer, but you will probably have gone back to the UK by the time the contract is ready, because it will take a couple of weeks, unless obviously you're planning to stay in France for a month or so, in which case, very nicely done. If you are signing a notaire contract, very often you will have to sign a French power of attorney rather than the contract directly. If it's done by the estate agent, they are actually a lot better with technology, and they will be able to arrange a remote signature for you. But in general, we don't tell you that you have to be in France to sign your preliminary contract. It is fine to sign it remotely, provided that you are obviously happy with the contents of your contract. Once you have signed your preliminary contract, what will happen is that your cooling off period is going to be triggered. So in France, a buyer of a residential property gets a cooling off period of 10 days after signature of the contract. During those 10 days, you can withdraw from the purchase for any reason. You don't even have to say why. You can just say, sorry, we've changed our mind. We don't want to buy anymore. Obviously, you will have to do this in a formal way to make sure that you are protected and there can be no fallback onto you. But you do have this possibility. Once your cooling off period has passed, you will only be able to withdraw from the purchase if one of the conditions precedent is not met. And it is very rare that they are not met. And obviously, that's why the redaction, the drafting of those conditions is so important, because you don't want to end up in a situation where you thought you would be able to withdraw and actually you cannot, or if you do, you would be at a risk of losing your deposit. Talking of the deposit, it is usually paid either on signature of the contract or within 10 days, but it is usually paid very, very quickly once you sign the contract. So you need to make sure that you have your currency, your euros, ready to be transferred to the notaire quite shortly after you sign your contract. So obviously, I cannot highlight how important it is to make sure that you speak to a currency broker like Smart Currency to make sure that you've got everything in place, ready to go for your trip, because there is nothing a seller hates more than a buyer who is a bit wishy-washy about, oh, my euros are not ready yet, I need to speak to someone. It doesn't make you look very serious, and then you are really at risk of losing your purchase.
Leah, can I just ask you, because
Yes.
we've got some questions about the deposit and the cooling off period.
Yeah, go for it.
It's a good point to ask them. First of all, is it always 10%? Is it something you can confirm through the agent at the point of making an offer how much the deposit will be, or is it always 10%
Yes.
when you?
No, it's not always 10%. Actually, at the moment, we see more 5% deposits, and there are even some areas of France where culturally there is no deposit paid, which doesn't seem very right to me, but we have seen some contracts signed without deposits. But yes, your agent will be aware of not only what is done locally, but also what your seller's expectations are. And a deposit is something that is, negotiable. If you only have that much cash available because you need to have a large mortgage, then you say, this is only so much we can pay. We know it is under 5%, but it is still a big sum. Is this acceptable? So if you don't have your 10% ready to go, you can always negotiate it. If you've got a reasonable explanation, I don't see why your sellers wouldn't agree with that.
Oh, that's good to know. So that's great. Thank you. And then Adrian asks, at what point do you pay it? When you've said on the signing of the compromise of the contract?
Yes. So
or at the end of the 10-day cooling off, is it?
It changes. It is, again, weirdly based on local customs. It sounds weird saying that, but that's the case in France. In North, we do things differently than in the South. The draft contract will tell you when the deposit is expected. Obviously, if you pay your deposit within your cooling off period and then you withdraw, under French law, your deposit must be returned to you within 21 days. I personally think that paying your deposit before your cooling off period expires doesn't make any sense, especially when we're talking about currencies. If you're getting euros to France and then you have to get your euros back into sterling, you can potentially lose out in terms of the exchange rate. So ideally, with our transaction, I always ask whether it is actually possible to have it paid after the cooling off period has expired. But obviously, if locally there are other expectations, then that's not always agreed.
Okay, thank you. And with the cooling off period, can the seller pull out in that period as well with no penalty? Is it a cooling off period for both parties? No.
The cooling off period is only granted to the buyers. That's why it is much nicer when you buy properties in France and in England. Your seller is actually technically committed from the moment they accept your offer.
Okay.
And they cannot withdraw at any point in the process. If they withdraw after signature of the preliminary contract, you are entitled to claim a penalty from them, which is usually equal to 10% of the price of the value of the property. Obviously, that's a theory. In practice, if your sellers, disappear into nature and you can't get a hold of them, it is very difficult to get court proceedings started to get 10% of the sale value out of it. But they, in theory, are not allowed to sell to anybody else. If they did sell to somebody else, you would be entitled to get that other sale cancelled and the property sold to you.
Okay, that's good to know. Thank you. Yeah, that's all the questions. So we're
yes,
for now.
On that point, buyers might be interested to know that in France, if you make an offer at the asking price, the seller has got no choice but to sell the property to you.
Oh, that's interesting.
So,
okay.
Yeah, there is no gazumping in France. It is actually illegal. As soon as your seller receives an asking price offer, if you're the first person to make an asking price offer, they have to sell to you. They can't actually say, oh, do you know what? This asking price offer came in really quickly. Maybe we did something wrong and we should sell at a higher price. No, that's it. They're done for. They have to sell the property to you at the asking price. So maybe obviously that's something to discuss with your agent, whether you love the property so much that you just want to make an asking price offer straight away to prevent your seller from maybe holding out in the hope of a better offer. And that's even if your offer is subject to financing. An asking price offer must be accepted whether or not you need a mortgage to finance your purchase.
Okay. And then we get to completion, obviously.
Yes, so once your preliminary contract has been signed, your cooling off period has expired, either the notaire will keep working on the file or they will be passed the file to start working on, and they are going to start building your file in readiness for completion. This means that they are going to carry out a number of local searches. They are going to get a town planning certificate so that you are aware of the local planning rules which apply to the property that you are purchasing. They will obviously check the deeds to the property, that there is good title, etc. And they will, one of the most important process between signature of the contract and completion is that very often the local authority will have something called a preemption right. So that's a right of first refusal, where they have to be told that this purchase is happening, and they get 2 months to decide whether actually they want the property themselves or not. If they do say, yes, I want this property, you as buyer, unfortunately, have to walk away. You cannot do anything to prevent that from happening. And if the local authority does not reply during the 2 months, then the sale to you can proceed. It is very rare that the local authority actually gives a reply. Most of the time, they just receive the notice and they don't do anything for 2 months. Though in some areas of France, if you are in a rush, you are allowed to pay a fast-tracked fee, which is of a couple €100, just to get the local authority to reply to you quicker than the usual 2 months deadline. In your preliminary contract, there will be a deadline for completion. And then it is a matter of you agreeing with the sellers exactly when you want to have the actual appointment. We would always recommend that you attend completion in person, because you need to check the property beforehand. You need to check that it is clear, that all furniture, included or not, is there or is not at the property. You should have by then taken some advice in terms of estate planning and wills and ownership structure to make sure that the deed are all structured the way you would want to. And then obviously the notaire, usually a couple of weeks before the agreed completion date, will send you a statement detailing the balance of the fees and sale price that you have to pay to them. And then that's it. You go there, you check your property, everything is in good order. You go to the notaire's office an hour later, you complete, you get your keys, and usually actually what happens is you go to the French bank so that you can finally open your French bank account, because you have your certificate of purchase, and the bank can no longer tell you, no, you can't get a bank account straight away. So most of the times that's how things happen in practice.
So you need a
yes.
your own to open a bank account.
Yeah. French banks don't like opening accounts for people, and then when you've got your account open and you want to close it, they don't like you closing it either. So they are very interesting French banks, a law of their own. But yes, unless you've been renting in France, if you're purchasing, for example, a holiday home, until you've got your certificate of purchase that you get on the day of completion, they will not let you open a bank account. It's always a bit stressful because you want to set up your direct debits, etc. So that's why people usually go straight from the notaire to the bank. But things do end up falling into place, and very often your estate agent can, give you a hand with all of those logistical bits. They're very good at that.
Great. Excellent. Thank you very much. Very comprehensive. One thing I'm going to ask is, what are the purchase costs that you should budget for on top of the agreed purchase price? So you've got to cover your notaires fees, your fees, disbursements, or any taxes, stamp duty, that sort of thing.
Yeah, so in France, the buyer is the only person liable for the notaires fees, and actually calling them notaires fees is not very fair to notaire, because they only get about 2% of what you pay them. You should budget, in terms of the mandatory cost, 7 to 8% of the purchase price, in addition to what you're paying your sellers. And this comprises the notaires fees for the drafting of the paperwork, but also the French stamp duty. In terms of our fees, this is outside of the French process and something that is negotiated between us and our clients. At Bocuse, we've made a decision not to charge a percentage of the purchase price, because we feel that sometimes, you're buying a very expensive property, but actually it was very, very straightforward, whereas sometimes you are buying a property of a more modest value, but there's been lots of building work done and actually lots of research and work to be done by us to make sure everything is in good order. And that means that this transaction could end up taking more time than a transaction on a more expensive property. But we will always give you, a very clear estimate of what you should expect to budget for our fees in addition.
Okay, thank you. One of the questions here is relating to the energy rules, the new energy rules.
Yes.
So that they understand that the government's trying to improve the lowest bands, F and G.
Yes.
When they say improve, does that mean introduce tighter rules to hit those grades? But the question is, if you buy a property and it's a low band, would you be liable, or could you be made legally to make improvements? Does a property have?
Yes. The answer to that is yes. So that's what the new law is in place. France does not want any properties in France rated G or F anymore.
Oh, really? So you have to bring them up to those levels. You will have to.
So you will have to. For the last year and a half, we've been waiting for the decree, but now for properties that are low rated, your sellers have to also provide you with an energy audit. So this is going to be a very in-depth document that will tell you exactly what improvements you can make on the property and on which bending the property will go once you've done this building work, and also how much it will cost. It has been something that has been quite difficult to manage lately, because obviously a lot of properties in France are, very rural and they are not energy efficient at all. And making a property energy efficient can be very expensive. F-rated properties must go in the next 3 years, and the one above must be gone by 2030, I believe. So it is, there is a very strict schedule in place to make all of those properties go away. And there is a point, I believe, where the French government will not allow properties at the lowest rating to be sold anymore. You will have to improve them before you can even put them on the market.
You can sell them.
So obviously, for people who are buying, even if the rating at present is still acceptable, they should keep in mind that maybe in 5-10 years time, when they're looking to sell, they will have to make all of those improvements before they can even put the property on the market.
Okay, there are some more questions. I've just seen another slide. Have you got 2 more? Do you want to finish the slides?
This one is just an illustration for people to look at while we go through our questions.
Oh, okay. Oh, perfect.
Yeah.
We are just running over a bit, but we'll get through. There's 3 more, but just to answer them quickly, if that's all right, and then people can find you in your booth afterwards. Is it right that as a buyer, you can only see if there are any planning applications for a property once you've committed to buy? So at what point does that due diligence come in the process, or would you know that before you sign the compromis?
I assume planning applications for neighboring plots of land.
I suppose so,
rather
yeah.
than the property itself, because otherwise the question doesn't make sense. You actually at no point are told whether there are planning permissions on neighboring plots. That's a question. If this is something that is of interest to you, and it is a very good, very important question to ask, you will need yourself to go to the mairie and ask them the question. And usually they will tell you. It depends if they are in a good mood or not, which happens very often in France. But it is not part of the standard process. The notaire will not tell you, by the way, 2 houses over, they're going to put a wind turbine in the garden. You're not going to be told anything like that.
You have to go and ask yourself.
You have to go, and that's not something that the notaire will do for you, because it does not form part of their obligations.
Is there a portal, like a council portal with applications like we have over here? No. Okay.
No. we're not quite just yet in France.
Well, that's a very good point then. Thank you for that, to whoever else that.
Yeah, really good question, actually.
Very quickly, stamp duty is a flat rate of 5.8%. Is that right? Stamp duty.
It depends on the region of France. There are some regions like Brittany where it is different. I personally don't have a brain for numbers. I need to check them all the time. But there is a very good online calculator on the notaires website where you can put your area of France where you're buying and your purchase price, and then it will tell you exactly how much you should budget, including notaires fees, stamp duty, etc. So the website is much better than me at doing the math.
That's good. Yeah, that's the notaire.fr, isn't it?
Yes.
I think.
Yes.
Yeah, that is a good website. Can a property still be purchased on tontine?
Yes, absolutely.
What does that mean exactly?
Yeah, so tontine is a way of creating a right of survivorship over the property. So basically in France, when 2 people own a property, the default way of owning it is called en indivision, which works a bit like tenants in common in the UK, in that when the first person dies, the surviving owner does not automatically inherit the property. Instead, the half share will go into their estate to be distributed to their beneficiaries under a will or under intestacy rules. A tontine is a provision that must be included at the time of purchase, and it creates that right of survivorship where once the first person dies, the second person automatically owns the property outright. two things to know about the tontine. The first one is that it does not avoid French inheritance tax. There is somewhere an article on the internet that tells you that if you have a tontine, you don't pay inheritance tax. That's wrong. Don't believe that. And the second one is that once you have a tontine, if you separate or you have a dispute with your co-owner, a court does not have the right to make an order for sale, which means that you are basically stuck owning the French property unless both you and the other owner are in agreement with what should happen to the French property. And also, once you've got the tontine in, you can't remove it to go back to estate, etc. So let's say, you know, you own it with a friend and actually you're like, oh, I don't want my friend to have my property, I actually want my children to have it. If you've got a tontine in there, you can't do that anymore. So tontine has its uses, but it needs to be very carefully considered against many, many different estate planning factors.
Sounds like a conversation you had with you before.
With your lawyer, yes, that's something.
Before you go and look for property or put a deposit down. We're well over time. I'm sorry, we've got a couple of the questions, but like I said, Leah is going to be at the Buckle Solicitors booth after this session, so you can go and ply her with questions all for the rest of the afternoon, and I'm sure she'd love to help you. So please do that. Otherwise, thank you very much, Leah. Really appreciate your time and excellent information. There's a lot to talk about, as we can see, and the questions are coming in now, but sadly we've only got half an hour. So thank you very much, everyone, for tuning in. I hope it's been useful. Good luck with your purchase plans in France. Enjoy the rest of the event. Like I said, the session has been recorded and will be available on the Your Overseas Home website, I believe, from Monday onwards, so you could go back and revisit this. Otherwise, enjoy the rest of your day. Thank you. Thanks, Leah.
Thanks, Richard. Thanks, everyone. Bye-bye.